पॉलिसी बाजार पर 1 करोड़ रुपए का टर्म लाइफ इंश्योरेंस केवल 450 रुपए महीने से शुरू। Wow.
Let's just listen in to those live proceedings.
Advance on both the sides. We have reframed 6 questions. I'm reading this. The first is whether the power available to the central government under subsection 2 of section 26 of the RBI Act can be restricted to mean that it can be exercised only for one or some series of banknotes and not all series in view of the word any appearing before the word series in the subsection. Specifically so when on earlier 2 occasions the demonetization exercise was done through the plenary legislations. Then 2, in the event it is held that the power under subsection 2 of section 26 of the RBI Act is construed to mean that it can be exercised in respect of all series of banknotes, whether the power vested with the central government under the said subsection would amount to conferring excessive delegation and as such liable to be struck down. And 3, as to whether the impugn notification dated 8th of November 2016 is liable to be struck down on the ground that the decision-making process is flawed in law. In the 4th, as to whether the impugn notification dated 8th November 2016 is liable to be struck down applying the test of proportionality. And 5, as to whether the period provided for exchange of notes by the impugn notification dated 8th November 2016 can be said to be unreasonable. And the 6th one, as to whether the RBI has an independent power under subsection 2 of section 4 of the 2017 Act in isolation of provisions of section 3 and section 4(1) thereof to accept the demonetized notes beyond the period specified in notification issued under subsection 1 of section 4. Insofar as the first issue is concerned, we have considered the judgments of constitution benches in the cases of the Chief Inspector of Mines versus Lala Karamchand Thapar and Banwarilal Agrawal versus State of Bihar. And the third one, Tej Kiran Jain and others versus Sanjeeva Reddy and various other judgments of the various bench strengths, wherein word any has been interpreted. And it has been held that the word any has to be construed in context to the statutory provisions. And then the second principle which we have considered is the purposive construction. We have referred to the Constitution Bench judgments in the case of M. Petia and others. Then Chief Justice of Andhra Pradesh versus V.A. Dikshitulu and others. And Tinsukia Electric Supply Company Limited versus State of Assam, apart from the other judgments. We have held that the modern trend is of pragmatic and not pedantic interpretation. The interpretation leading to absurdity and which renders a provision to be futility has to be avoided. Any interpretation which advances the purpose and object of the legislation has to be preferred when 2 constructions are possible of a particular provision. And applying these principles, we have held that a restrictive meaning cannot be given to word any. And insofar as issue number 2 is concerned, again refer to the Constitution Bench judgments in Hamdard Dawakhana, Tarakchand, Ratanchand Pantia, and Birla Cotton and Spinning and Weaving Mills. We have held that for finding out the policy and guidance, a resource can be added to various provisions of the Act, including the preamble, the purpose of the Act, and what is necessary is that the parent statute must consist of an essential legislative function, that is determination of legislative policy, and it is permissible in view of the multifarious activities that it is necessary for the legislature to delegate the working of details. When we have considered the status of the RBI, we have referred to the judgment of the Constitution Bench in Joseph Kurila, then the judgment authored by my learned brother Justice Ram Subramanian in Internet College, and we have specifically emphasized on the primary role of the RBI in issuance and regulations of banknotes, then its important role in monetary and economic policy of the country. Then we also considered the nature of body to whom the delegation is made. In the present case, the delegation is made to the central government, which is answerable to Parliament, and Parliaments are in fact answerable to the citizens of the country. In this respect, 5 was held unconstitutional. In the very same judgment, the Constitution Bench has held Clause A of subsection 2 of Section 5 to be constitutional on the ground that it provided that the administrator can take action after consultation with the RBI, and therefore there was self-imposed provision which required the RBI to be taken into consideration. Applying the same principle, we have held that in the present case also, the central government is required to take the action after recommendation of the central board, and therefore there is an inbuilt safeguard. Insofar as third issue is concerned, we have basically relied on the judgment in the case of Tata Cellular, wherein the scope of judicial interference in matters pertaining to is very limited. Then we have further referred to various Constitution Bench judgments which are specifically dealing with interference insofar as economic policy is concerned. The judgment in Prague Ice and Oil Mills versus Union of India rendered by 7 judges. Then R.K. Garg versus Union of India. Then Sri Sitaram Sugar Company versus Union. And which has been held that there has to be a great deal of restraint insofar as interference in the matters pertaining to economic policy is concerned. The court cannot substitute its judgment for that of the legislature or the executive. It does not supplant the feel of the experts with its own views. And we have also scrutinized the record, and after examining the record, we have found that the judicial decision-making process cannot be flawed merely because the procedure has emanated from the central government. We have construed that the term recommendation has to be construed in the context of the statutory scheme, and what is contemplated is a consultative process. And from the record, it appears that there was a consultation between the RBI and the central government over a last period of 6 months. Then, insofar as the fourth issue is concerned, we have considered the 4-pronged test held in modern dental education. One, as to whether the action was designated for a proper purpose. We find that the 3 purposes are proper purposes, and whether there was a reasonable nexus of the measure with the purpose sought to be achieved. And we have held that there was a reasonable nexus. Then, insofar as the third test with regard to alternate measures is concerned, there cannot be any alternate measures for the action which is thought to be done by demonetization. Then the fourth one is whether there was proper relation between the importance of the purpose to be achieved and the limitations on the constitutional rights. And applying all these 4 tests, we have held that the action cannot be hit by the doctrine of proportionality. Then issue number 5, with regard to reasonableness of period is concerned, we have considered that in the 1978 Act, the period provided was only 3 days, and which was extendable by a further period of 5 days. And this has been found to be a reasonable period in the case of Jayantilal Shah by the Constitution Bench. In the present case, the period provided is 52 days, and therefore, applying the principles laid therein, it cannot be said to be an unreasonable period. Then, insofar as issue number 6 is concerned, we have held that the entire scheme of Section 3 and 4 has to be considered. The powers under the provision of subsection 2 of Section 4 cannot be construed in isolation, and therefore, the RBI does not have an independent power. Insofar as hardship is concerned, we have referred to the judgment in the case of R.K. Garg and Sonia Bhatia, and we have also considered that it is not relevant as to whether the objective thought has been achieved or not. So what is required is that there has to be an objective which is for the proper purposes, and there has to be a reasonable nexus with the measure and the object to be achieved. We also held that we cannot direct the central government to exercise its powers under subsection 2, and it is for the central government to exercise such a power if it finds that the exigency so arise. Accordingly, we have answered the reference as under 1. The power available to the central government under subsection 2 of section 26 of the RBI Act cannot be restricted to mean that it can be exercised only for one or some series of banknotes and not for all series of banknotes. The power can be exercised for all series of banknotes merely because on two earlier occasions the demonetization exercise was by plenary legislations. It cannot be held that such a power would not be available to the central government under subsection 2 of section 26 of the RBI Act. Then second, subsection 2 of section 26 of the RBI Act does not provide for excessive delegation inasmuch as there is an inbuilt safeguard that such a power has to be exercised on the recommendation of the central board. As such, subsection 2 of section 26 of the RBI Act is not liable to be struck down on the said ground. In 3, the impugn notification dated 8 November 2016 does not suffer from any flaws in the decision-making process. 4, the impugn notification dated 8 November 2016 satisfies the test of proportionality and as such cannot be struck down on the said ground. 5, the period provided for exchange of notes by the impugn notification dated 8 November 2016 cannot be said to be unreasonable. And 6, the RBI does not possess independent power under subsection 2 of section 4 of the 2017 Act in isolation of the provisions of section 3 and 4(1) thereof to accept the demonetized notes beyond the period specified in notification issued under subsection 1, section 4 of the 2017 Act. Having answered the reference, we direct the registry to place the matter before the Honorable the Chief Justice of India for placing it before the appropriate benches. Needless to state that all other contentions are kept open to be considered by the benches before which the matter would be placed. Before parting with the judgment, we place on record our deep appreciation for the valuable assistance rendered by Sri R. Venkatramani, the Learned Attorney General, Sri P. Chidambaram, Sri Shyam Diwan, and Sri Jaideep Gupta, Learned Counsel, and all other counsels appearing for the parties.